Let me share my screen. Okay. All right. So thank you for joining us today. This presentation, this workshop is brought to you on behalf of the ICRR Business Center. We are a we're operating a grant in partnership with the Chicago Minority Supplier Development Council. If you're not familiar with the council, if you are a minority business and you're interested in doing work with government contracts, doing work with government entities, with corporations or large contracts, and you want to get certified, this is the organization that does it. So they specifically are doing the minority certification, and they are placing minority businesses with opportunities from larger corporations. So the corporations have buy-in, and then they're looking to work with minority businesses. So getting certified and working with the council is certainly of benefit to you if you're interested in doing that type of work. So just to give you an idea about the ICRR Business Center and what we're here to do, again, we are a grant-funded program. Our program ends at the end of June. And so what we're here to do while we are in existence is to assist minority-owned businesses in urban and rural areas with understanding and taking advantage of resources and services that are being made available by the local, state, and federal government agencies. So a lot of those COVID resources that have been available, programming that's been available, grants that's been available, really trying to create workshops, networking opportunities to connect minority businesses to those opportunities that are available. So we're doing this through education and training, focusing on things like finance, supply chain, organizational development, technology, sales, and legal support. And so with that being said, today we have our wonderful speaker, Ms. Lauren Morgan, who is a business law attorney specializing in contracts, business consulting, and strategy and entity setup. You will get a email following this presentation with this particular pitch deck. So it'll have Lauren's direct link to her social or her LinkedIn specifically. So I encourage you to get connected with her on social media. Also, she'll take a deeper dive into her background. This is just a high level, but we are bringing speakers like Lauren in, like other, again, industry experts based on the needs that are expressed by people like you who are participating in our workshops. So if there are additional things that you need where we have not brought a speaker in to address those needs, please let us know, because we do have access to speakers, and so we can create those workshops for you to address those needs. So my name is Christina Wynn. If you don't know who I am, I'm a consultant for this particular program. I'm also a business owner. I own the Winners Club. So when I look to bring speakers in, I'm looking to bring speakers in that I know have the knowledge and experience with small business, because a lot of the things that you all are learning, I'm learning and experiencing as well. So I'm very happy to be able to bring Lauren in. If you need anything from me, again, if there is interest in any type of particular workshops or networking events, we have the resources to do it. So please shoot me an email. That is my direct email there. And then again, we want to say thank you for participating in this workshop. If you ever want to contact our general team or our program director, Irma Lopez specifically, feel free to use this email, icrr@chicagomsdc.org. And as we transition into Lauren's presentation, I will give you an opportunity to scan the QR code, and you can use this QR code to complete our intake form. So this will ensure that you are a part of the correspondence that goes out about the different workshops that we have coming up, and our May calendar is filled at this point. Okay, Lauren, I got your message. Our May calendar is filled at this point. So we will have workshops almost every day in May, and we're looking to fill up the June calendar as well. We do have some in-person networking events that are coming up also. So like I said, make sure you take this opportunity to complete the intake form so that you can be aware of those opportunities when they come down the pipeline. Now, I'm going to stop sharing my screen so that we can go into Lauren's presentation. Awesome. And now I will pass it over to our illustrious speaker today, Lauren Morgan.
Hi, everyone. Thank you so much, Christina, and the Chicago MSDC program for having me here today. I really look forward to presenting to you guys and kind of talking about, some of the ways to set up your business and your entity, and really position yourself to be able to take advantage of the great opportunities that this program is connecting you guys with. Christina gave an overview about myself. I'll tell you guys a little bit more about myself. Here is just overview of me and my firm. I am the founder and attorney behind Activated Law. I am a business attorney that specializes in all things business that touches, right? So that's from entity setup, intellectual property, such as trademarking and copywriting, contracts, and I touch on employment matters as well with clients. So I have about 7 years of experience in law, 5 years with my own firm, and I have been a business owner since 16. I started my first business and I just live and breathe business. So a lot of these things outside of the legal aspect of it just come really innate to me and really natural. Is something I'm very passionate about, something that if I don't know how to figure it out, I know where to go to figure it out because that's my training and skill set for it. So all things business, if you guys have questions, I know Christina is a great resource as well, but specifically for the legal things that I'll be presenting about today, be sure that you follow up, ask questions, engage. There is no wrong question, no stupid question, anything of the sort. And I really love talking and educating people on this stuff to equip and empower us to move forward and do better. So with that being said, let's hop right into this. I have a lot of great content for you guys today. This is going to be part one. I'm going to give an overview today on different entity structures. How to go about picking your business name, what are some of the steps that you should take in putting those things in place, some of the general contracts that you should have upon setting up your business and your entity that will help protect you as well. And then lastly, I'll end and close on touching on some intellectual property stuff, specifically trademarks. And then in part two, tomorrow, I'll come and I'll do a deeper dive explaining more in depthly about different type of entities, some of the benefit, pros and cons of each. Today, I'm just going to do like an introduction of each. And then in part two tomorrow, I'll do a deep dive into each one of these same subject matters, just giving more so of some of the pros and cons, some of the processes of putting things in place, just an overview more so in depth of what we covered today. So with that being said, first things first, we are going to talk about setting up your business and entity types, right? And so a lot of things that people don't consider when they're setting up their business is a venue. And venue shopping simply means which state or which venue, right? State is going to be interchangeable for venue, is going to be most favorable for the entity that I want to set up. There are a lot of things to take into consideration here, but a few of the things that you want to consider are annual requirements. Is my state going to require me to have to report an annual upkeep of this every year, right? So I'm licensed out of Arizona. And in Arizona, there is not an annual requirement for LLCs. However, I have clients and I've set up businesses for people in Illinois. I'm originally from Chicago too, by the way. So very, very, you know, particular and very big on Chicago businesses, Illinois businesses. And so I'm very familiar with those processes as well because I have clients there. And so to that point, Illinois does have a requirement for both LLCs and corporations that you will have to be mindful of, right? And it's really in this stage is about counting our costs and having a forethought plan of how to sustain and maintain our business even before we begin the business, right? Because so many businesses start out, you have an amazing idea, you have a great, you know, great something, a great passion that you want to capitalize on, but you don't think through the plan, and therefore your business isn't sustainable, and you end up running into things that eventually prevent you from succeeding in your business, right? So with the venue shopping, not only do we want to consider if there's an annual filing requirement, we also might want to take a look at some of the fees that are associated with this, right? Some entities, for instance, Nevada has a very high setup fee for corporations initially starting out, but their maintenance fee over time is going to be less. But why would you want to consider Nevada? One of the things that you might want to consider are the tax implications, right? Nevada is a tax-free state, meaning you're not going to pay any state taxes. You're only paying federal taxes. And that might be something, depending on your business type, that you might want to take into consideration as well. Now, a lot of people by default just end up setting up their business in the state that they are in. And that's not necessarily always the best way, right? There are some states that are very friendly, kind of sort of similar to what this program offers, right? That they have some laws or some incentives or some grants in place, depending on your business type, that you might want to position yourself to take advantage of. For instance, I know Wyoming was a state. They're also a tax-free state as well, FYI, but Wyoming is a state where they were trying to get business owners to move there for a particular field. They were offering an incentive for business owners who were coming there and setting up shop within a certain time frame within this business, right? So partnering with some people who are doing research or who are aware of this information and this knowledge can be very beneficial. Now, for the sake of this workshop, obviously, Illinois is one of these states, right? This program is one of the many programs that are out there that are setting business owners up for success, offering incentives and offering grants. And this is one of the programs that I'm giving an example of that you might want to consider, right? The other thing that you might want to consider is tax liability. For instance, California is a state where no matter how much money you make off top, minimum amount of money that you will be paying for your taxes in the state of California for an LLC that makes $0 or makes more money is going to be a $800 tax liability, right? That's a lot of money to have to be liable for your company for, despite what it is that you are making. Of course, that base number goes up as you get revenue in and you're making more money, but that's something that you want to be aware of and take into consideration, right? That might be something that's burdensome and cumbersome if you're in the infant stages of your business and really setting it up and you're not really generating a revenue to sustain that tax liability, right? So those are some things that you want to pause for, take into consideration, and really hone in on if your business is going to be sustainable over time because of the venue that you have selected to set up your venue, right? The next thing you want to think about is once we know kind of what the venues are and what the different venues are going to require based off of the entity that I choose, you need to decide on the entity you're choosing, right? So I'm going to go over the types of entities, which on a base level, there's really two types of entities, right? There's a LLC and there's a corporation. For the sake of just full coverage, I will also talk about a sole proprietor and what that is, or a sole proprietorship. Basically, a sole proprietor is what you are as soon as you have a business, right? If you have an idea, a hobby, you make your first sale, congratulations, you are in business, you are a sole proprietor. And basically, what a sole proprietor is, what a sole proprietor does, is you are solely responsible for all things that take place and happen with your business. If somebody wants to sue your business, if somebody is having a complaint, you are solely individually responsible for that business. Now, this comes to the importance of setting up an entity and why you want to set up an entity, right? And when you set up an entity, you are partnering with your state that you've chosen, the venue that you want to be in, and you are holding yourself liable to the state, and they are backing you to say, we back this company, and we are agreeing to allow them to practice and, govern their business within our state regulations and statutes to correspond their business in the appropriate manner. And we are going to give them the protections of a separate individual for the purposes of running this business. So that means that as soon as you file a articles of incorporation with your state for either an LLC or a corporation, which we're coming back to that to break that down. I know some of you guys are like, what? There's an S corp, there's a nonprofit. I know, I got you. I'm coming back to that. But for the sake of simplicity, starting off, the two that we're focusing on will be an LLC or a corporation. Once you hold yourself out and the state partners with you to do so, they're going to recognize this as a completely separate individual that has its own rights of protection, that has its own shield, basically, that now you as an individual are taken out of the mix, right? You might still own it, you are backing it, but they are saying anything that happens with this business, this entity is going to be responsible for it, and you no longer are individually responsible. And that's a really big deal because life happens. We are human, we make mistakes. And in the unfortunate event that you are sued or something goes wrong with your business, your new entity that you have partnered with the state to create is going to assume responsibility as long as you have not acted grossly negligent in the event where something would fall on you personally, right? And so once you have this entity in place, once you choose which entity you want, it is going to basically absorb a lot of the risks that you would personally be liable for. Now, expenses and things like that, because you're the sole owner or you're the one of the members of this LLC or corporation, shareholder for a corporation, you might still be responsible for some of the expenses and things like that that are happening, just as far as the maintenance and a liability standpoint. But personally, if anyone were to sue the company, to sue that, they would not be able to list you individually under that, right? I'm going to come back to this a little later because there are some things you want to do to make sure you are actually getting the protections from this business in that sense. But overall, that's what an entity is. That's why you want to have one, and that's why you want to set one up. So I promised we were going to come back and we were going to talk about the different types of businesses, and we're going to really break down this LLC entity versus this corporation entity, right? So an LLC is a limited liability company, which means that you personally are going to have limited liability for the things that happen and go on in the company, including taxes. It has a pass-through structure where you are taxed individually, but as a business as well, where you can get a lot of the write-off structure, right? This is the most basic setup of this. I am not a tax consultant or expert, so I'm going to definitely point that you go to an accountant and get some more information on the specifics of that. But just in general, that's what that looks like, right? Now, let's come over to a corporation. A corporation has a lot of different types of businesses underneath of it that are essentially still a corporation, right? They are taxed differently, they flow differently. The setup for them is similar, is very similar though, right? Which is why I categorize them in those two categories. But you can have a S corp, you can have a C corp, which is generally the corporation as a whole. You can have a nonprofit benefit corporation is also another one, and well as a private nonprofit, right? Default status for a nonprofit when you set it up is public, but you can also have a private nonprofit, which mostly looks like foundations. A lot of people who have foundations might have a public, or I'm sorry, a private nonprofit where essentially it just talks about where the funding comes from primarily, not even a hard rule, but for instance, the Bill Gates Foundation is an example of a private foundation that is a nonprofit. So those are going to be the 5 types of corporations that you have the option of choosing and setting up once you set up. And basically, the pros and cons of those, each of those we'll get into tomorrow. But overall, there are a lot of options, honestly, when it comes down to thinking about what type of entity you want to have in place. So when we go into tomorrow, the breakdown a little bit more, we'll talk about, like I said, some of the pros and cons. A lot of people, the most common and popular one, honestly, is a LLC. A lot of people default into an LLC model because it's the easiest to set up. It's usually the cheapest to set up in a state, and that's what they know and they hear a lot about, right? And they're like, oh, I won't be liable for my company, which is true. But there might be some other things that you want to consider, such as tax elections, that you are taking in mind when you choose your entity. We talked about generally the LLC is a pass-through. S Corp has something very similar where you're not double taxed like a C Corp. It can pass through like an LLC, but you still get benefits of a corporation, right? C Corps are double taxed. Benefit corporations, depending on your election, you can actually still elect to be taxed as an S Corp. There's a lot of tax rules out there, which is why you want to consult with an accountant on how you can do this. You can even have an LLC that's taxed as an S Corp, right? And some of the benefits of that, once again, you'll want to talk with your tax accountant about or your tax expert about. But that is I would say, the last factor that you want to consider in really a holistic plan of action in moving forth with your business, right? Real estate has always been and is definitely now with the new innovative products out here, such as VRBO, Airbnb, so on and so forth, where real estate is a really like booming market right now. Real estate is always, it's a staple for our economy. It's always booming, but it's very innovative right now. There's a lot of new things that are happening and taking place. And to that point, there are certain states that are going to be very friendly for the tax elections that you're setting up, right? And that might be something that people really want to consider on the forefront of setting up their business versus on the back end of that, right? So when it comes to setting up your business, before you even go to pay any money, before you do anything, there are some big decisions that need to be made, some conversations, some research even that needs to be made. And these are some of the beginning points of where I would start with that. From there, other things are going to come up. Honestly, like I mentioned, um, just based off of your business type, based off of your industry. I know a lot of tech companies are very big into California. That's actually migrating to different parts of the company. Arizona is one of them right now. Texas is another one where people are migrating for their innovative technology companies. But you might want to consider what the market looks like, right? Where's the demand going to be? Where's your ideal client going to be at? And so, from those different perspectives, people choose to move and do business there because they're going to sacrifice and basically just plant their roots there. So, over time, for networking and marketing, they will have a name that is in a place that will bring them a lot of business through the long term end of their business goals, right? So, a lot of things to consider here. All of them are not listed, but from a legal aspect, you want to make sure that these things are in place. And even though technically the elections are not something that is legally set up on the front end, having they can be changed on the back end is what I mean by that. But having those conversations, I've talked on the phone and during this period with clients, I've talked on the phone with many of accountants because we need to have discussions on what their goals are and what they need to do money wise. I need to understand that so I can set them up legal wise, or what their legal goals are. Is that how do we set that up so it's going to complement what their money goals are as well as a company. So great conversations to have up front. The quote where it says everybody needs to have a lawyer and accountant on the team. You really do. And not necessarily when you are established as a business. That's kind of, I would say, the misunderstanding that a lot of people have is that, oh, I can't afford all of that right now and I need to do it later down the line. You honestly can make some very, very detrimental pitfalls if you don't consult with them up front. And this doesn't mean you're retaining an attorney or bringing on an accountant to do all your books every month, but really investing in the time and the education up front, doing a consulting with an accountant and attorney, paying for that can save you a lot of money in taxes. It can save you a lot of money from having to convert your business because you set up the wrong business, or having to move your business to a different state that's going to be more friendly to you in the long run. So really want to make sure that you are considering these and taking them into play. So with that being said, we're going to move into, I kind of talked about this here, but we're going to talk about just the comparison, right? I want to give you guys an overview of, once again, the two summary breakdowns of the business types that are here in present. And so I'm not going to explain everything here. I don't want to insult you guys. I can send over a copy of my presentation as well, so you have it for reference. But just some comparisons of how these are going to look different, right? I've already gone over what LLC stands for, what a corporation is, some of those types. And I vaguely touched on that members are a part of LLCs, and then you have stakeholders, stockholders, or shareholders for a corporation. LLCs are member managed. Corporation has it's done by the stocks and the shares of people in the company. They vote on that. They might even have a board of people who maintain the day-to-day decisions, the quarterly decisions, the really big decisions, and then they are the ones who present it to the rest of the company, the stakeholders, the shareholders, to make that vote. Owners of an LLC can have a percentage of the LLC as well as in a corporation. That percentage is determined based off of the amount of shares one has in a corporation. And really, when it comes to setting up these two entities, the type of documents that you're going to use are going to vary based off of that as well. So for an LLC, you're going to have an operating agreement that you're going to use and put in place and really have going for everything. This is an agreement basically between you and the company that talks about what it is that you are going to be responsible for in the event that something goes wrong with the company. What's your action plan? And once again, it doesn't have to be that you are personally liable for it. The state wants to make sure that you have an action plan in place so the company is responsible. And once again, staying ahead of the plan, being proactive in the event that things happen versus not. This is legally required by all states to have an operating agreement. Actually, I think it's maybe 2 or 3 that don't have them, but most of them are getting on board with this and making sure that they have some type of agreement in place so that they can hold the business liable if things were to go wrong. For a corporation, this looks like bylaws, right? This is legally required for every single entity that you are setting up with, or every single state that you are setting up with. for every entity type of a corporation. Your bylaws need to be in place, and these really go into depth about the roles of the board, the roles and the positions that the board holds. So president, secretary, treasury. It talks about, you know, the different rights of the shareholders, the stakeholders, how votes are handled, how annual meetings, which are required by corporations, are going to be handled. It's a really, really in-depth document of the operations of the corporation and how things are going to be handled annually, day to day for meetings, how people can do different votes based off of different shares. Corporations can get really, really dense. You can have different types of shares, right, with different voting rights. It gets really, really complex, which maybe I'll have a chance to go into a little bit more tomorrow, but an overview of that. It's really cool though, because it allows you to have different options and different things in play with your corporation, and you get to make a lot of decisions. And this happens, we see it happen in everyday life. This is just a legal explanation of it on the back end. But when you see people are splitting stocks and there's a type A, there's a type B, I think Google has about 4 minimum types of stocks. Some of them are public, some of them are not even listed, that they give just to their employees and different, like the founders of the company that they hold, and they don't share it out. So you can do a lot of different things with your corporation and your stocks and your shares. All of this is going to be explained and detailed out in your bylaws, though, right? So that's a really good entity comparison. I keep going back on this the wrong way. Sorry, guys. So once you have that general foundation in place, so once all of that is rolling, there are some things that you want to start off with and make sure that you have in place for every single company that you are putting in place as far as businesses, right? The first agreement, honestly, is going to be that operating agreement and those bylaws. A lot of people don't recognize, but that is an agreement, a legal binding agreement between the business and the owners of that business, that they are saying and stating and putting on file with the state of what that's going to look like and how they're going to operate, right? But moving out of that, employment IC agreements might not apply with everyone. So it depends on where you are in the stage of your business. Most people, when you're first getting set up, when you first have that entity, these are not going to be something that is a priority for you. But I'm going to highlight and talk about confidentiality, non-disclosure agreements, and non-compete agreements today, because I'm going to venture out to say no matter what stage you are in your business, you probably will want to have some aspect of this in place for protection. And I'm going to explain why. Employee agreements, IC agreements, we can actually deep dive into that further tomorrow. So I won't neglect it altogether. We'll just revisit that tomorrow and go deeper into that. But a confidentiality and non-disclosure agreement, this protects your ideas and the things that you are working on in your business. This is crucial, especially for businesses who are positioning themselves for investors, who are positioning themselves to, get grants, certain things that you are wanting to line yourself up for and get even new people that you're trying to invite into the business. If you're trying to see if they're a good fit, some level of disclosure has to happen about what your business is, what your business is doing, what your future plans are for your business. But you're talking to people who are potentially in the position to go and act on these ideas that they didn't have immediately once they find out about your business, right? I know, Donna, you were talking about, doing future ventures with people. This is where this would come into play, honestly, for me, is in the idea stage of that. A lot of times you talk about stuff with people and you're sharing stuff and ideas come out of that and people want to run with it. But in that infinite stage of that idea, you want to protect that as you really sit down and you start to hone out what this is going to look like, what this business is. Even if we decide not to move forward, I don't want you taking my business ideas and running and going and partnering with someone else. And now you are becoming my competition. And this was an idea that we had together. I have unfortunately seen this happen so many times in my business and my firm. And a lot of the initial conversations are happening. People are acting off of good faith. People are, working with an investor. They are working to finalize agreements. This is in place before you even finalize agreements, right? This is literally at the talking infinite stage. There is an idea in play, in motion. We want to protect the information that is being shared in this room right here, right now, before any type of, product, service, any type of production comes out of it. We want to make sure that we are covered on the ground level. And that's what a confidentiality non-disclosure agreement would be about. And you want to make sure, like I said, that is in place very, very early on in a lot of the initial conversations, because I have seen so many people lose their business because they've had these conversations. Things have been in play. They have been setting up businesses and they have been finalizing agreements. Agreements are in talks already. They're finalizing and they're like, oh, that's going to be good as soon as we sign the agreement. And one of the people takes it, they have the money and they're in position and they go and they do everything and X them out of it. And they come and they're like, what are my rights and what are my protections? And I'm like, well, where's your contract? And they say we don't have one. And the reason we don't have one is because we were working on a partnership agreement or whatever that looks like, right? Whatever people think that that's the finite agreement that needs to be had, which it is, but it's not the beginning stages of it. It doesn't end and start there. It ends there. We need to have a different starting point, and this is the starting point. So I forgive me if I'm belaboring this point. I can't tell you how my heart breaks when people come to me and there is nothing I can do to help them because they are in this position. And so I really, really want to hone in on this, the importance of this, because it happens every single day. Every single day, people's ideas are being stolen. People's ideas, people are running with it and implementing it and putting it in place. And here's why you don't have protections over it. Technically, do you have protections? Can you go and do stuff? Yes. But as attorney, I'm going to counsel my clients and let them know this really isn't a favorable a lawsuit that you should take on or a fight that I would see a good outcome coming for you. And the reason for that is you don't have any type of written agreement of what that was, right? You have maybe some emails going back and forth saying what we're going to meet at this time, we're going to talk about this, but it's nothing really concrete. Nothing people have agreed to. What that shows is that you were discussing some stuff and potentially that they stole your idea. So that might be enough to establish that there was a conversation happening in play. But what happens because there's no endpoint of a final contract in place is it becomes he say, she say. Well, actually, I didn't steal their idea because I took and interpreted whatever email it was as they weren't going to move forward with this anymore, or there was a delay. So I thought I should still move forward and get started with stuff. And that's what happens. Unfortunately, a lot of time and time again, I see it happening, and people really don't understand why they don't have protections at that point. And here's the truth. You do. You can go to court. You can sue for whatever you want to sue someone for. But it becomes a frivolous case because you don't have enough evidence to back up your case and come out successful. So for me, that's not even a case I would take on, right? I'm not here to nickel and dime people and get them out of their money, but it's a burdensome case for me to take on because I have to now come and pull thin air to come up with a defense for you on this, which really doesn't exist, right? You're going to spend a lot of time, effort, and money going to court to fight something that isn't going to be favorable, right? You're really kind of pulling at pins and trying to piece something together that unfortunately does not exist because we don't have a finite point. But having an agreement in place, even at the start, that says this is the idea that we are talking about. This is the time frame in which we are trying to put it together. This is when we are trying to do it. This is the role that each party will have in that. And each party is agreeing that we won't disclose, give this to other people, or work on this without each other. In the meantime, while we build this project up, is invaluable because now that is a concrete agreement that I can say, hey, our clients agree to this. Your client is in breach of this, even though it hasn't come to production in its fulfillment of everything yet. So that's a really, really big agreement. A lot of people don't have. I'm like, please have it. It's so important. Whatever, if you get a template for it, my business has templates for it. Just get something in place. I promise it is worth it. If you get a template, you can change out the names and things like that for people in the future, but it's worth every penny. I promise you, it will save you a headache that is inevitable to come because life is life, and we do business sometimes with people who aren't on the up and up, or life just happens, right? So you just want to make sure you're protecting yourself and have that. A non-compete agreement is a little bit different. This is usually something that is going to come in play once you have something established, but you are rolling out people. This is like the beginning stages of people coming to work with you or partnering with you on an idea that you still have, right? And sometimes it couples with an NDA, a non-disclosure agreement, because we're working on this idea together, right? We are agreeing that we're going to do this. You fully understand the process. I fully understand the process. And what I don't want to happen is if things don't work out with us, I decide to move forward. You also decide to move forward. And guess what? We're across the street, setting up shop at the same business and entity. And we are competing and going against each other for the same idea that we were working together with or that I exposed you to, right? This happens a lot with ICs, independent contractors. They come into your business, they work for you, they have all these great ideas. You're giving them great ideas. And then all of a sudden they're like, oh, I can do your business better than you can. I'm going to take your ideas. I'm going to implement this, and I'm going to do it at a higher and bigger level than you. That's the illusion of seeing people in their lane and doing things. People think that it comes so easy that they can imitate you and put it in place and steal it. I deal with this a lot of times from clients as well, in industries that people think are very easy entry, right? They'll come in, they'll take their entire website, their logo, they'll change some colors, and they'll compete with them and try to do stuff. And usually at the end of the day, when we get to the bottom of it, it's usually someone who was actually an IC at the very beginning of their business or their setup stages, and it didn't work out, or the IC went somewhere else, whatever the case may be. But non-competes, like I said, can partner with NDAs. They also partner with employment agreements, IC agreements, which we'll delve deeper into tomorrow. But NDAs, non-compete agreements, have them. They are what protects you in that infinite idea stage of really having your ideas and your products stolen, at the very infant stages of it. So here are some tips around having those contracts, right? At the very beginning, I stress this, y'all need to have a contract. Make sure that you have a contract. If you don't have one, there's nothing to protect. It is he say, she say, picking at thin air. It is going to be really hard to form a defense. It's going to be really hard to even find legal counsel who will represent you with that, because I see that from a mile away and I'm like, headache, headache, headache. You can't pay me enough money to take that on. There's nothing I can do from you. And I don't, that becomes a very disgruntled client. You get bad reviews. It's not worth it, right? Have a contract in place. Even if it's something off of Google, I'm like, this is not a good contract. It has zero protections in place. I can still try to build a defense around that because there's some type of agreement that is in place, right? So usually I work with clients, get that agreement in place, and then quickly thereafter, we'll get them a better contract in place too, right? Next thing I want to tell you guys is make sure you have arbitration agreements in place. Why is this important? I keep saying it. This is life. Life happens. We're human. Mistakes are going to happen in your business. Some processes are going to fail at some point in time. Systems, no matter how hard we work on it, glitches are going to happen with technology, whatever the case may be. It's going to happen. And you want to make sure your business is protected in a way that while you make mistakes, there is a cushion for your mistakes to catch you when they happen, right? We know they're going to happen. That is life. So we want to have a plan in place for it. Arbitration is a private, less expensive, and quicker turnaround time for decisions being made versus court, right? Court is long wind. It takes forever to get in front of a judge. A lot of times there's a lot of back and forth. It's expensive because you hire an attorney to do the back and forth with people. They're doing all the complaints. It's very, very tedious, very expensive process with that. And it's public. Anything that is in the court system is going to be public record. Now, they might decide to kind of redact the record so you can't see everything and visually see all the incidents that happen, but you have to, then again, that's another thing you have to request from the court, is a redaction of what happened in the case, so it's not public knowledge. And even with that, people can go with different security levels, different appeals, get stuff unsealed for different purposes. The best policy is to go with arbitration, which by default is private by record. And arbitration is court enforceable, right? So if there's an arbitration on the list and things like that, and there's a decision that's made and the other party isn't acting on it, you can take that arbitration decision, take it before a judge, and get them to pass a judgment on it, which now forces an enforcement and has the exact same weight as if you had gone to court in the first place. There's been a shift in the legal system in the past 5-10 years where the court systems have become so saturated, right? As business booms, as life is taking off, people have become more litigious. So there are more lawsuits there. The courts are bombarded, especially when COVID happened. Nobody was prepared or expecting that. All the court things that were on the books, everything got moved to online, which took a transition and learning curve. We're trying to get used to that. So a lot of court systems are actually implementing and requiring that people will have a arbitration system in place by default, right? And so this really requires and allows people to position themselves where they'll file a lawsuit, things like that, but the court will say, hey, before you even come to us, go to arbitration and allow this to happen. I think it's still good to have an arbitration agreement in place because all court systems are not the same way with this happening. And it's usually a recommendation. They are just trying to buffer their system. We're saying go to arbitration, see if you guys can reach an agreement. And if you can't, then you have to come here. If there is an arbitration agreement in your contract and your clause already, it is mandatory that you start there. So you are immediately not having to go through the wait process of the court for that to happen. You are immediately waiving the fees that you have to do for filing a case. You still have to pay for arbitration fees, but like I mentioned, they are significantly different and lower. And so having an arbitration in place and that clause also requires that this is the way that we are going to handle this. There is no, if we can make it happen, cool. If not, we're going to go to court. We are coming to arbitration, and that mediator is going to help us see through, or arbitrator is going to help us see through to an end result of this matter that we then can take to a judge and get enforced. But we have decided in our agreement that this is how we're going to resolve this. So this is how it's going to be resolved. So it's a more concrete way of seeing arbitration through and making sure that matter happens versus allowing a court to push you into arbitration. My last tip for having a contract, a lot of people don't do this. You do the work, you put everything in place, you get a contract there, and then unfortunately you forget to sign in your business name. You are still signing your personal name without a title, without your company name, and now that cancels everything that we've worked so hard to put in place. You are legally responsible individually, and I'm sure your company name is probably going to be somewhere throughout the contract. So your company is still technically liable, and now you are personally liable for it, right? I have caught clients up on this, or not my clients, but I've taught a lot of my clients how to not to do that. But this has actually worked in favor for me with some of my clients and agreements, right? Where they've had contracts with individuals and they have gotten them out of hundreds of thousands of dollars of deals, right? They've scammed them, whatever has happened. And I go back and I fine tooth comb every single agreement. I look at all the onboarding documents, everything that's happening, and I see, oh, they didn't seek an attorney and counsel before signing this. So they didn't know not to sign this in their personal name, not to give their personal address when they have a business address and a business thing, right? This is a rule of thumb. When you set up that business, you set up a personal individual. But if you want to keep the rights and the protections of that personal individual, you cannot treat it and act like it is you. Even if you are the only person running it, it has to be separate. You have to have your own bank accounts for that. You have to have your own, not necessarily business address, because you can have home offices or things like that. I recommend having a business address, even if it's a virtual office, because all of these things that we're filing are public record. If a disgruntled client comes in, finds you, they are now coming after you personally. We don't want that. We want to protect ourselves in every single front. So having some type of virtual office address in place where people don't know where you live and your physical address is going to protect you physically. But from a legal standpoint, the more you can show that this is its own individual, it has its own bank account, it has its own business address. It is completely separate from Lauren. Lauren runs it, right? But Lauren, all of Lauren's information is something completely different from the information set up on this business account. You are going to be able to show them that this is the business that should be liable, right? And we're going to hold that business to that state, right? So we go to all these measures and we go through all these things to set up these things, these protective barriers, but then we sign in our personal name, and now we're still personally liable because I signed in the authority of myself personally and not in my authority of the business. Very quick, small nuance to overlook, but it's a very important nuance because someone like myself, where you have tried to scam my client out of hundreds of thousands of dollars, and you set up this business, your business is making money, cool, but you're not really feeling the pain of that. You did it intentionally. You don't want to you kind of pay for it through your business. You're going to make whatever excuse. But if I can tie you to this personally, if I can make you personally liable for this, you will feel the sting and you will take this lawsuit seriously. You will do what you need to do to try to settle with my client outside of this to make amends and to provide restitution to my client for the matter, right? So that is just a tactic for attorneys in going after things, right? So you want to make sure that you are protecting yourself and signing under the authority of your company and not your individual authority, which could possibly destroy the protection that your company is giving them. Now, both of your companies, both of you guys, your company and you are listed parties to this lawsuit. That's what happens. And it's your defense, right? I'm the one who's suing or pressing charges. It is going to be your burden of proof to come and say, I shouldn't be personally liable. Now you have to work and spend your time and your money to present the case on why you should be removed. And if you can't establish that, right, if I can come and say, well, no, you provided your personal security number, not the EIN number of the business, right, which is really important. The EIN is the social security number for the business. You provided your home address. You signed in your name. There's nowhere on here where you have your title and the name of the company. Even though on other documents you do, on these documents you don't have that in place. That lets me know you were getting paid, right? The separation of the bank accounts. We were paying you as an individual, not as your company, even though you signed some agreements in your company name. I am destroying that because we were paying you for over a year's time, whatever the case may be, as an individual, which destroys you trying to say that your company should be liable. Both of you guys are going to be liable now. So making sure you sign under your company name is going to be very, very important in this instance. Okay. All right. So this is going to be our last topic for today. We're kind of winding down. Christina, I don't know what time we started. I know we got started a little late. So I feel like we have another 15 minutes at least to wrap this up. And
Definitely. Yes.
okay, perfect. That's going to be just enough time for us to cover the last topic with your intellectual property. And really, guys, these are stepping stones, right? So focusing on the entity, making sure that that's in place, making sure that you're good to go there, then moving on to your contracts that are going to protect, once again, another layer of protection to your business. So ideas aren't being stolen, aren't being poached. But even with that, you spend a lot of time branding your identity, working on your products or services that you are selling to people. We want to make sure that we protect them. These are the three different types of protections when it comes to your intellectual property, right? Patents are going to protect your inventions and things that you come up with. And I always give this example. My favorite patent ever is the Michael Jackson shoe that allows him to do the lean, where he leans over and he doesn't fall. There's actually a patent on a shoe where he kicks out a certain way, a nail comes out, allows him to be anchored into the ground and to bend over without falling to give the defying gravity illusion that happens. He does something, a kick back when he comes up, it takes the nail out of the ground and he's able to come back up and to continue walking around and dancing during his performance. But genius idea. It's my favorite. I found this out maybe 4 or 5 years ago. I had no idea it was a patent for his shoe. And patents have a very, very long expectancy once they're approved. It's a very tedious process to get patents approved because every little component of a patent is patentable, right? So if you are creating a wand with a tool that drops the ball into a really, really tiny sign, like something for the body in surgery or something, that wand can be patent, that ball can be patent, the material that you use can be patent. So if any part of that process is already patented by someone else, you now cannot patent that, or you need to find another way to create something that's different to patent that entire process. For that reason, patent applications are very tedious. They are going to be very expensive to hire an attorney to patent those. For you, it takes a long time, but once you get that, they will allow you to have that patent and hold it in and out of death for a very long time. You can renew it easier too, but you hold that patent for a very long time without having to do a lot of renewals. Trademarks are going to be a little different. Trademarks are, and they're in order of difficulty, cost, and things like that. Patents are the most difficult to get and acquire. They're the most expensive. Trademarks are going to be like the middle ground. They're expensive. They're a little bit more difficult as far as the wait and the time. And there's a lot of saturation happening right now with trademarks that I'll go into a deeper dive in tomorrow. But trademarks are going to protect your brand, right? There are 5 areas that you can trademark, which is going to be your business name, your business logo, a business slogan, a business hashtag, or a business color, right? Anything essentially that is associated with your brand that when I see, think, or hear something, I associate it with your brand. And just some examples of this are going to be more so like the slogans and the not the hashtags, but the color, because your business name and your logo, that's easy to get a hashtag, that's easy. But an example of a color is going to be Tiffany blue. Tiffany blue is everywhere. You see it branded a lot. It's a very pretty turquoise color that's out there, kind of turquoise greenish, but you will never find another jewelry company that is using Tiffany blue. I don't care if they are fake cosmetics, things of that nature. Tiffany Blue, honestly, because of their rank and their establishment, their just their history over time, they don't really fight with the small dogs anymore because it's very clear this is not Tiffany, right? I'm not going to fight you on this. This is knockoff, counterfeit jewelry that doesn't compete with Tiffany's. But I assure you, if a Zales or another company of that stature that was more profound, they're still not on Tiffany's level, I know. But if they were to come out and to do a Tiffany blue stone or anything of the like, Tiffany's would be suing them because they own market ownership in monopoly, honestly, for that color in that industry for jewelry. Like I said, it's not worth it for them to go after these little small dogs that are charging $5, $10 for little pieces. that's honestly brand appreciation for them. People know because of their history. They Tiffany would never, right? So that in and of itself, because they have invested in their brand and their marketing in monopoly by saturating, what Tiffany Blue is, this is how we sell it, this is how we present it, because they've done such a great job with that. Over time, they still hold that trademark. No one else can come in and compete with them. But even the ones that are trying to compete with them, it's very clear that this is not our brand because we've done such a good job establishing our brand, right? So that's what a trademark is. And that's why that's important, because you spend a lot of time, a lot of money, a lot of research sometimes into what color is going to get people to react a certain type of way with my brand, what color is going to respond and make people feel this type of way, right? What slogan is going to be catchy where people can remember it and they'll sing along to it, and they'll, when they are in need of something they think legal, they're like, oh, we want to go here because that slogan is in their brain, right? Anything along the lines of that is something that you're going to want to do for trademarking. Just do it is one of them. Nike has so many different catchphrases that we know as soon as we hear it, we don't need to see Nike. We don't even need to hear Nike. We think Nike because we hear that phrase that has nothing to do with Nike outside of them taking it, creating a brand for it, establishing that brand. And that's what we do. Just Do It has nothing to do with shoes. It has nothing to do with Nike. But when we hear it, we think Nike. Same thing with Swoosh. They are just one of the goats. And as far as just market domination when it comes to trademarks and it comes to brand recognition, they do it, and they do it very, very well. So those are two examples of kind of the slogans and the colors that might be a little tricky to identify that way, right? And so lastly, we have copyrights. Copyrights are going to be for any type of artistic piece of work that you have and that you are registering for. So music has a copyright associated with it. Paintings have a copyright. Photography has a copyright. Website, poetry, anything artistic that you create. Your books are going to have one. This is really big. A lot of people are writing books now, since self-publishing, since COVID, being in the house. A lot of people are like, oh, I wrote a book. I came out with this book. And in that process, what we're finding is that copyrights, you actually have an inherent copyright from the moment that you write your book, right? Or create whatever artistic piece of work. You have that. Write a claim, timestamp from the time you created it. However, if someone is to go and steal your website and steal your logo, what's your brand, all of that, a logo, once again, would be a trademark, however, but a lot of times copyrights and trademarks overlap, which is why I'm using this example. If someone were to go and to steal that and to say, no, this is my website, if you were not registered with the copyright agency, you would then have to defend and to show proof that you had this website, this language, all of that before this person had it, which can be very tedious when you are trying to run a business, when you're trying to handle life, when you are working full time still. And because copyrights are so easy and cheap to get, it doesn't really make sense why you wouldn't, right? So copyright ranges between $45 to $65, just for like a book or a script or something like that that you are registering, versus if you had a copyright in place that was a book or something like that, you could submit it, get the claim for it, have it on file, versus someone just coming in, stealing it, and saying, no, I wrote it first. And now you have to battle with them about who it is, which once again looks like someone going to court, filing a suit and saying, hey, this is my copyright, they stole it, so on and so forth, right? So it just is worth the effort for copyrights. They're very inexpensive. If you do series, sometimes it gets up to like $100, $200. I think the most expensive copyright for one item, depending on what it was in that field, they have a lot of different categories for it. I think it was about $600, right? Which, for the cost of your product, your business, whatever it is that you're doing to protect that, have peace of mind, and not have to have that battle, I'm going to argue it's going to be worth it every single time, right? So these are the differences between intellectual property, patents, trademarks, copyrights. My next couple of slides kind of go into a deep dive for trademarking. For the sake of time today in part one, I'm not going to go in depth with them. I'll go at a high level because we're going to circle back to those tomorrow and talk about that trademarking process more in depthly. So, like I said, this is an overview of the trademarking process. The purpose of a trademark, I just kind of explained that for you. The processing of it, I'll talk about it tomorrow. But something really cool that I will talk about today is the difference between a trademark and a service mark. The overall process is called trademarking, and that covers service marks. But a lot of people, it's not required for people to do it. It just kind of has become a default mechanism for people to associate it with a trademark. But technically, if you have a service business, if you are in the industry of not having a product, right? This is a service, we have a logo, things like that. You technically have a service mark, right? And you very rarely see this. I can't even think of a company right now who is using this appropriately, but instead of seeing TM, you should see some marks that say SM. And all that means is that they still have a trademark, right? But they have a business that is a service, and so they have a service mark. And trademark really is for products and things like that. But like I said, most people are using TM just across the board right now. That probably is one of the shifts that is coming, where they will get rid of the SM altogether in the future. But right now, that's just kind of one of the ways in which that is being navigated and handled. I talk about that here. I also list here, like I said, the 5 areas that you can trademark and what that is. And all of this will be available in the slide deck. So I'm going to skip over that. What the purpose of a trademark is really quickly as well. Like I said, we'll deep dive into the process of a trademark tomorrow. But I really just wanted to highlight the purpose of a trademark today. It really has 2 purposes, and the 2 purposes are for 2 different audiences. One, they want to protect the consumers, right? If I am searching for a car, right? I'm searching for a Lexus, and I'm new to cars. I don't know that much about it. I'm not in the car industry. I don't know how they sell it. You're welcome, Donna. Thanks for being here. Basically, you want to make sure that that consumer is educated enough to know the brand. So we want to prevent other people from getting access to this and being able to really saturate the market and really overflow it with things that are going to confuse consumers who are coming to spend their money on it. Basically, fraud, right? Scams. This is one of the ways to prevent that, is saying this business is registered with the trademark, this business is not. So this is the business that owns this branding and this marketing. So if someone were else to come along, you should know that this is not the person to do business with. The other part of that is to protect the business owner, right? I've invested a lot of money with my branding. I've invested a lot of money in building my business. I don't want someone else to be able to come and rob me of that just so quickly, right? And so what that looks like is registering your trademark and protecting it against other companies who are popping up and saying, hey, we're going to do the business with a similar or same name. You're going to say, no, I actually have a federal trademark for this, and I'm going to send you a cease and desist. So you cannot do that, right? So that's one of them. This is the process, which we'll delve in deeper tomorrow. And basically, that's all we have for today. I know Donald had to hop off, and I still leave this up for people who are watching the live recording back. If you do have questions, please make sure you let Christina know. You can reach out to me. And with that in conclusion, she gave you guys my LinkedIn profile that you can connect with me on, but this is also my contact information that you can reach me at as well. And I will turn it back over to Christina with that being said.
Awesome. This was awesome, Lauren, as usual. You broke it down really well. And I think that tomorrow will be, yeah, you can go back to your pricing for sure, because if they need your services, that's why we're bringing you in. None of us are attorneys, none of us offer this service. So we want to bring them education, but also let them know if they need the support that you are able to do it. So please utilize Lauren and Activated Law's legal services. I personally use the services, and it has worked very well for me in different business ventures. So like I always tell you all, I only bring people in that I can personally vouch for. And so I can personally vouch for Lauren and her services. So please utilize those. We will be back tomorrow. As mentioned, we're going to take a deeper dive into some of the things that were spoken about today. So please make sure you watch part 2. It will be equally as rich in content. And so I encourage you to make sure to continue to take advantage of the resources, reach out with any questions, and just always know that I'm here to help however I can. So make sure to stay connected. All right, we're going to stop the recording.